Hi, everyone. Thank you for joining us today. My name is Katie Spoden. I'm an assistant director over at the Polsky Center. Thank you for joining us for today's workshop. I'm excited to introduce our facilitator for today, Dr. Omri Ben-Shahar, who is the Leo and Eileen Herzel Professor of Law at the University of Chicago Law School, and also the Kearney Director of the Coase-Sandor Institute for Law and Economics. He teaches contracts, sales, trademark law, insurance law, consumer law, e-commerce, food law, law and economics, and game theory. Today's workshop will be about digital contracts and the adoption of terms and the legal standard for when you're creating contracts within your business and typical mistakes made by designers of digital environments. If you have any questions during the presentation, feel free to put those in the chat, and Omri will get to those at the end. So with that, Omri, I will hand it over to you.
Hi, everyone. It's nice to be here. I would be delighted if some of you want to turn on your webcams so I can actually see faces that I talk to while I lecture, but no pressure if you are not set up for that. Also, at some point, if you do want to interrupt me, not via chat, but ask a question while I explain something, you're welcome to raise your little yellow or blue or whatever color hand you chose to have. I might even ask you some questions as we go along. If you want to, we can have some discussion. But for that, you have to have your faces shining at me. Okay, I'm a law professor. My main interest is in consumer protection and consumer markets. And one of these interests has brought me to think a lot about how consumer contracts are created and how websites and businesses manage the rights that they have vis-a-vis consumers. These things have become very charged, even ideologically important in our society, contested politically. Arbitration clauses, data policies, cookie policies, and all of these are governed by the contracts that the websites and businesses employ in their relationship with consumers. So we're going to talk about digital contracting, and I have some. I'm going to put my slides on. Here we are. Are you able to see? Good. Just a second to arrange my screen. Okay, good. So digital contracts, well, everybody knows what it means to sign a contract. You went to the bank, you took a loan, you rented a place, you have a paper with paragraphs and a line at the bottom, and you sign, and you recognize at the moment of signature that what's happening has legal consequences, that you're bound to it, whether you read it or not, whether you understand it or not, whether you realize that you are taking upon yourself some commitment that requires to be somewhat cautious when you do that. We don't do it, usually do it with thinking about it and recognizing the momentous event of signing a contract. When we do this digitally, sometimes there is a similar momentous event of signing on a digital screen. For example, when you rent a car at LAX airport, you stood in line for 15 minutes to get to the counter to rent a car, and you usually will see a screen where you can sign digitally instead of what used to be the printouts that were given to you by the car company. But digital contracts can have many other forms, surprisingly less momentous than the signature, the hand signature that we are used to from the brick and mortar world. So I'd like to first talk a little bit about these, what do they do, these digital contracts, that is somewhat different than regular contracts, or in addition to regular, and then how they are formed, and some of the things that you ought to know when you build an environment in which digital contracting is part of what you do, either as the business side or the consumer side. Digital contracts govern rights in the transactions that are formed electronically. via websites, via apps, email, with either clients, suppliers, partners, employees, the general public, anyone you can think of with whom contractual arrangements are entered into formally. They also govern not just the service that the business gives, but the way in which the digital environment interacts with people. So the business might be a business of offering people some kind of, let's say, help you find a parking spot wherever there is, where is a vacant parking spot. You do it through through some digital interaction, and that creates all sorts of opportunities, for example, to collect data, to track people. The use of the digital interactive platform is itself governed by the contract, importantly so. Let's go over a few possible ways in which digital contracts are formed. One is, I've shown you the electronic signature. Many of you may have seen something like DocuSign. You sign a document, but instead of printing it out, signing, scanning it, then emailing it, you can also sign it by choosing what cursive font to use for your name and just click sign wherever it is. Notice, interestingly, this is just a sociological observation, that in these documents, if you sign the lease of some kind, let's say it has 12 pages and you have to initial each page, there are usually these convenient buttons next, like the one you're seeing here, namely how to find the next line for signature without having to read. The whole notion that anyone ever reads these contracts is a big myth. I've written a lot of my scholarship about the non-readership phenomenon. Nobody reads anything of these, but that doesn't matter. They are binding whether you read it or not. And these next buttons are just little helpful shortcuts to get to where you want to be, which is to complete the transaction. So electronic signatures is not much different than the old kind of contracts, but now we're getting to things that are more interesting in the digital domain. And by the way, electronic signatures include sending an email with your name. Someone shot you an email and said, hey, how about if we do the deal this way? I give you X, Y, and Z, you give me A, B, C. And you sign and you send back and say, okay, sounds good, and sign Omri. Just type my name. I have just signed the contract. It might be formalized later, but in the same way that, agreeing in email by signing your name is a contract, has contractual consequences. Let's talk about what we call in the legal lingo click wraps. These are click, I agree contracts. So sometimes they have the format of you scroll down and see the terms in the bottom, click, I've read this term and I agree to that. So something like this. The terms are above, you scroll and you accept the contract by clicking a button, not by signing. Here is this is kind of an example of a scroll text where at the bottom you can, doesn't have to be the button, there's always this button of I agree, which you can click and save yourself the hassle and the inconvenience of actually having to scroll. But sometimes you do have to scroll all the way to find the I agree button. I'll get the question in a second, but here is another example. You scroll down and you have the option at any point to click I agree to the terms and conditions. Yes, Mark.
Hi, Professor. Thank you. Just a really quick question. You mentioned email agreements before. If you ask someone to agree to terms in an email and they say yes, I consent, but don't necessarily sign their name, but it's obvious who it came from, is that still a binding contract?
Yes, there is. These things have evolved as the modes of communication evolved. The legal consequences have too. So in the era when people sent faxes, courts used to say the fax has to have your letterhead on top for it to look like a formal signature. But to the extent that there is a requirement of signature, then there needs to be a signed name. Contracts can be entered into orally without a signature. Contracts can be entered into informally, and therefore it can happen on email without signing someone's name at the bottom. Going back to the click I agree contracts, I gave you the example of scroll presentation of terms. There is also a simpler way to do it, and that is just to link the terms. You click I agree to terms that are linked, and here is the hyperlink to see the terms. By clicking sign up, you agree to our terms, data policy, and cookie policy. You may receive SMS notification. These are all things you are agreeing to if you click sign up. Why sign up? Because it says that by clicking sign up, could have said anything. The button could be called George. By clicking George, you agree to our terms and conditions. As long as it is clearly told you what is the consequences of clicking a particular button and it is not misleading, you have just signed the contract. Terms are not here. If you need to see the terms, do yourself the favor and click on one of these highlighted linked hyperlinks, and then you will be taken to another page. Sometimes it's a long page. Usually, always it is a very long page, but this is the law recognizes this as a sign, as a moment of signature. Here's another example. You get to some kind of a checkout page. They want you to prove that you're not a robot. They want to give you the option to sign to or sign out of promotional messages. But then there is this language at the bottom, right above the blue create account button, that says that clicking create account means that you agree to Microsoft service agreement and privacy and cookie statement. So these are the very typical and the most successful and the best way to get agreement done is to get people to actually click and to click something that's called I agree or join or buy now with a statement that explains to them that by clicking this, they are accepting terms that have either been presented above the click or are linked in a way that is conspicuous. Sometimes, and this is now getting to more surprising legal results, terms can be linked to the digital in the digital environment, and they can become part of the contract without any signature or a click. These are called browse wraps, and this is an area of the law that has been increasingly being clarified over the last decade. So I just went before, when I was preparing the slides, to ESPN.com, where I watched the UEFA, the Euro Cup, too often, too much now in the mornings, and I'm missing an important game right now because of you all. So I hope that those of you who are not showing their faces are not actually doing this because you are enjoying the game while I have to work. Anyway, so I went to ESPN.com and scrolled to the bottom of the page, and here's what I saw. At the bottom, there is this terms of use and privacy policy. Now, you can click on each one of them and you'll see that there are all sorts of agreements. Namely, that if there is any kind of dispute that you have with what happens to you while you're in this proprietary environment in the website that's called ESPN.com. For example, they plant some devices in your tracking devices in your computer, or they suck out so much of the information that's in your app, that's in your mobile device through the app. You might be complaining and you might want to sue them and you'll get a lawyer, but you have agreed in the term of use that you can only sue them, let's say, in a court in Texas, or only go to arbitration. So they've created an agreement in which the consumer has given up some rights or received some rights, or the website made promises. We will never share your information with the government or something like this. This is a contract. But how was it created? You never clicked I agree to anything. Well, you entered into their proprietary environment, I call this, their space, and stayed there. So they decide how to govern things. If someone came into my house and I have a sign in the entrance to the house that says, anyone who comes into this house might be recorded by some hidden cameras. By coming, if they see the sign, if there is a sign that says that and they stay in the house, they don't have to say, I agree. It's my house. You walk in, you accept the terms of the owner. So that's the premise of these linked terms. And so no link, no signature is needed, and the contract is formed without users' affirmative agreement. By staying in the website or the app, using the content, the user is regarded by the law as agreeing to the terms of the service posted in the link, but only if the link to the terms is placed in a prominent place. Now, I've shown you the ESPN link. I had to scroll all the way down several, it is a long homepage to find the link. That's not very prominent. There are important decisions by courts, all in every court in the country that have said that this kind of placement of the link is not good enough. Consumers don't see it. ESPN has not gotten good legal advice. Maybe they don't care too much. Who's going to sue them for? But it is better to place the link in a very prominent place. This is the equivalent of, here's a photo I took when I walked into a mall one time that says liability limits. If you park your vehicle here, you are, at your own risk. You don't like it, don't park it at our station, at our garage or at our mall. We're giving you the opportunity to come into our proprietary environment, putting on a notice. This is the equivalent in the, again, you see even bricks here, brick and mortar world, to the ESPN link. This is a contract. And this is a term that the consumer, the individual, accepted. Finally, there is another way in which terms can be accepted, and this is pay now, terms later. We call it terms in the box. You log into Amazon, you buy a Samsung device. Do you have a contract with Samsung? Well, whatever it is, the terms of that contract, the limits on liability, the arbitration clause, the warranty, whatever, will be in the box. You open the device, you open the box. First, there might be some insert paper, or there might be something that when you launch the laptop, you open the laptop, there will be a README file with the terms and conditions. All of these things arrive long after you concluded the transaction. You paid and purchased. But these terms can be binding as well, as long as there was some alert, some notice at the time of the contract that the terms will be arriving in the box. The contract is formed at the point of sale, but the additional terms that are sent later with the product or by mail can become binding. So these are the ways in which digital contracts are formed. I want to say a few things about the comparison between digital contracts versus paper contracts. So the first thing that is entirely apparent is that digital contracts are longer. Consider for a moment that, for a minute, the contrast between shopping at Walmart, the store, the supercenter, walking into it and shopping, and buying the same articles at walmart.com. Do you have the same contract with Walmart? Well, at walmart.com, if any of you will go to the website, you will see a linked terms of service. Or if you actually buy something, during checkout, you will be accepting terms of service, just like the examples we saw before. None of this happens at the Walmart store. It only happens online. Why are online contracts so much longer? It is, I want to give you an example of how long they are. So, this is the iTunes terms. This is me, and these are the iTunes terms and conditions that I had to accept during one of these periodic updates that the iPhone does and asks you to, or the App Store terms and conditions asks you to accept new terms. So I just, before I accepted, I emailed it to myself and then printed it. 30 pages long of 8-point font. This is tens of thousands of words. All I was trying to do is purchase a track for 99 cents. But this happens in the digital environment. That's my point here, is that it's not happening in the real stores, in the digital. And the question why, you can think to yourself, what are the reasons? But part of it is that imagine giving you a 30-page contract every time you purchased a pack of gum at Walmart. It's just a lot of paper. Digital contracts don't need paper. It's written once and it is disseminated, replicated endlessly. They are not just longer, they are formed in a more passive manner. We've just seen how digital contracts are formed. You enter a website, bang, you have a contract. You never notice these things in the real world. It doesn't happen so easily, because when you're asked to sign, there is a signature and a pen and a line, and that kind of momentous feeling that we are signing a contract. In the digital environment, it is happening all the time, and nobody notices. People don't notice that, and they behave much more passive towards it. They just click, I agree, in order to close the box. Every time you enter into a new website that you've never visited, there is all of a sudden you are blocked and saying, we have a cookie policy. We have a privacy way in which we follow you and track you. And most people view this as an annoyance that there needs to be kind of brushed away. So they close a box, click in order to make this pop-up go away. Do they think that they've just signed a contract? That they've just agreed to give access to everything that's in their computer to that domain? Also, digital contracts are different in the sense, as we already began to say, that they deal with additional topics, with the data and privacy issues, with ownership of digital content. You're going into a website and you're going to upload something or say or do something. Who owns this content? You just posted a photo that you took. Usually you have copyright in the photos that you have taken. Not if you agree to give it. Where did you agree? In the terms of service that you clicked I agree to, or that they were linked to in a prominent way. So if done right, digital contracts can have very powerful implications, but if not done right, they're just not binding. So it's really important to follow some of these guidelines, and I'll reiterate them. And we said I'm short in time, so I'm not going to repeat what's included in these digital contracts, but I've already mentioned some of these things. So the best practices in the presentation of a digital contract is agreement must be given in some way to the terms of the contract. Here are some examples for very powerful and important companies that failed to get people to agree. This is a page from a smartphone when a user signs up with Uber. Uber really wants people to accept their terms of service, both drivers and users. Why? Because if there is a complaint, if somebody gets hurt, if there's some whatever issue, they don't want to go to court, they want to arbitrate. That's the most important thing. They don't care to lose to an individual claimant. They just don't want a 10 million person class action. So they included that in their terms of service right here, and you see it in the little, I put an arrow to point to the hyperlink, and it says, what does the consumer say? They ask to give their payment information, click register, and underneath it says, what does it say? Let me put on my glasses. It's also not a good sign for websites if it's so hard to see. By creating Uber account, you agree to the terms of service of the privacy policy. A federal court said in 2017, that's no good. When people clicked register, they could not see prominently this notice, this warning that they are agreeing to terms and conditions. Therefore, they don't have to arbitrate. They can go to a class action. $100 million later or something like this, Uber would change this format to do it better. They failed to get agreement. Here is another example from Barnes & Noble. Sign in or proceed as a guest in order to purchase on barnesandnoble.com. And look, you can click sign in or click begin checkout. And underneath there is terms of use. But nobody told you that by clicking sign in, you're accepting the terms of use. There was no link between these two actions. So again, the court said terms of use are not binding. And finally, here's an example from a financial institution that wants you to open an account. It has a service. You see in the middle, there is a scroll box with a service agreement. And underneath, there is a text explaining to you what you've just done and a button, I accept, and continue to step 3. Well, let's focus in. Let's zoom in. The service agreement, you can scroll and it says, well, yeah, welcome to TransUnion, blah, blah, blah. This is the service agreement. It contains the arbitration clause and all that, blah, blah, blah. And then underneath, it says, you understand that by clicking I accept and continue to step 3, you are providing written instructions to TransUnion to obtain your personal credit profile. You notice what it is missing. It doesn't say that you understand that by clicking I accept and continue to step 3, you are accepting our service agreement. Nobody told that to the consumers. So the service agreement, that portion in the scroll box, is not part of the contract. Another big mistake that led to the business losing the ability to impose on the consumers their terms. Yeah. So this is what basically the law says. I'm just summarizing this. A standard contract term or contract is adopted as part of the consumer contract if the consumer manifests assent, shows their assent to the transaction after receiving a reasonable notice that the terms and of the intent to include them as part of the contract, and a reasonable opportunity to review the terms. Okay, so best practices, to sum up, best practices in the presentation of the contract. Agreement must be given to the terms of the contract. Get the people to say, I agree, and present the terms to them in a way that they can find them. And do not manipulate, because courts are going to be, and the law is very anxious about manipulation. I'll just briefly, before I get to the question, give you examples of how manipulation is happening, getting people's agreement without people understanding that that's what was done. And I think that you will see that it coincides with experience you've had. These are what are called dark patterns in the design of websites and of apps. Easy to get in, hard to get out. LA Fitness says, sign up for monthly membership or and you can cancel anytime, no commitment. But when you want to cancel, you go to the same place and you click on cancel, and then you see, well, it's not that easy. Say, sorry, you can't cancel through the website. You have to call an 800 number. Call an 800 number, and they put you on hold, and it gets, after 30 minutes, gets disconnected. You have to start all over again. That's a dark pattern. It's a pattern of getting you to stick with the contract and with their terms, even though you don't want them. Don't do that, because you get slapped hard on the hand once there is a complaint. Here are 2 other examples. Don't know where I can say no to automatic content sharing. Instagram tells you, yes, you allow us to share your content with anyone, and there's no button for no. You look for it, and either it's a very small link somewhere hidden, tiny little letters, no, or it just says, not now. So after 15 minutes, you'll get another pop-up. Can we now do it? Yes, not now. There is no simple no. Can I check out? Here's another dark pattern. A consumer thinks, can I check out without adding some additional features or add-ons? I just wanted to order food on Grubhub. And why is there all that stuff in the end? Why is my $17 meal became $35? Where are these things? How were these added on without me affirmatively adding on? Did I have the option not to add them on? That takes us to the big problems of hidden fees and add-ons that people didn't especially money fees, people didn't actually choose. In-app purchases, you got a cheap app, but there are all sorts of purchases that don't realize occur automatically. So all of these ways in which people are manipulated to buy things without actively choosing them and without easy way to say no to them are manipulations that increasingly courts and lawmakers are trying to stop. Okay. Yes, I have a question, Mr. Agarwal.
Yes, thank you for this session. And I think we apologize for keeping you from your game right now. But thanks a lot for the session. I just had one question with the specific example on Uber that you mentioned. So one is, of course, the fact that whether the user is explicitly reading the terms and conditions before he's giving his consent to enter the contract. And I've just learned that from you right now. But in terms of the clause on arbitration versus going on litigation, I think that has a deeper issue. Even if I, as a user, am able to see the contract and read it, and then they give me an option of whether I accept or not accept. But just the fact that they are able to put in a clause stating that in case of any dispute with Uber, I will not be able to engage in a litigation matter or a class suit action is itself, I believe, it just goes against some basic sort of common sense laws, I would say. Forgive me, I'm not a lawyer, but what would you say on that?
I think you touch on an important issue, and that is the actual terms of the contract, not how the contract is formed, but what's in it. And no doubt about it, business entities are trying to constantly push the envelope and to introduce more and more one-sided terms that favor them, not the consumers. They don't think that there's a lot of competition over this. Consumers don't scrutinize this. So they are trying to do that. And the law sets limits. There are things that are entirely unfair or illegal that they cannot do. For example, there was a practice that developed about 10 years ago when businesses realized that consumers are being empowered by posting negative reviews on Yelp and other places. So they started including terms, they called them non-disparagement terms. Part of what consumers agreed to in the fine print was not to post negative terms, with the agreement that if consumers do, they will have to pay a penalty. Now that seems entirely outrageous, but courts were gradually beginning to strike down such terms as being, they called it unconscionable, unfair, unenforceable. But finally, Congress in 2016 passed federal law. It's called the Consumer Fairness Act of something that prohibits these kind of clauses. A similar fight occurred over the topic that you just raised, the consumers agreeing to give up their right to litigation and give up their right to band in class actions and agree to go to individual arbitration when they have a dispute. Some courts around the country we're beginning to find that these are unenforceable. They also weaken consumers in a way that's not tolerable. But in a set of decisions by the Supreme Court that interpreted the Federal Arbitration Act, the court held that these arbitration clauses must be enforced all over the country. So this train has left the station. You can wave your arms in anger, whatever you want to say, and arbitration clauses are enforceable as long as the arbitration is fair. You can't have your spouse be the arbitrator. You have to go to a fair, neutral arbitration forum that gives the consumer or the employees or the users or whoever it is that agreed to arbitrate with the business, gives them a fair chance to get their complaint addressed. I'll just mention that that's what businesses now do. They don't care to win the arbitration. They just care to make sure that there is arbitration instead of litigation. Yes, Mark.
Hi. Just a question. When you were talking about the dark patterns, small businesses don't necessarily have like customer service departments. And I'm kind of wondering, are small businesses exempt from any rules, or not exempt, but is there leeway for them? Obviously, if customers call up to cancel a subscription or something, and it takes time for the small business to actually respond, how is that sort of treated in courts?
Yeah, I think that there is, small businesses are usually less of a target to actual litigation, and I think it's easier to usually find a way to resolve disputes without too much formality. They're trying to build goodwill, and they're not worried so much of class actions. That said, small businesses could be good or bad. They can try to trap consumers into a commitment that consumers did not realize they're giving. They might make promises that they don't intend to keep. They might sell value that they know is not there. And they might try to protect themselves by copying and pasting the terms of Uber so that they know, if it's good enough for Uber, it's good enough for us. Mostly, if any kind of small business is trying to get the consumers, suppliers, users, any party with whom they interface, be bound to a contract, and they want to do it digitally, it's probably not a good idea to draft the contract from scratch, but to do a little bit of research of what similar businesses are doing and scrap their content, use their terms. But be careful not to follow these best practices. Make sure that you get a consent from your customers, and that you don't try to trick them. You may incidentally cause hardship to your consumers. For example, they can't put a person on your 800 number all the time. But make up for it in other ways, and not hide behind your smallness to degrade the quality of the experience that users have. It's not just legal advice, it's business advice. There has to be a way to avoid trapping consumers and making consumers feel manipulated.
Just thank you so much. Just a general follow-up question, for the non-attorneys on this call like me, and who are looking for a primer on just where to get started. You posted a law on sort of what I guess like a standard contract term must contain. Could you any good resources, whether it's like a nutshell book or something that where we can sort of educate ourselves on this?
Yes, I will forward that. Katie, is that something you can pass to the participants after that talk?
Yep, I can send along any resources. I'll
give a list of resources that are that can be accessed easily.
Thank you so much.
Yes, Krishna, please.
In the aerospace industry, they have this long-term service contracts by engine manufacturers or the aeroplane body manufacturers, which last for like 25 years. So in those high-value contracts, which are long-term, have you seen this adoption of digital contracts?
Have I seen the what?
Have you seen digital contracts being used in that kind of settings?
So what happens in long-term supply agreements is that there is a master contract in which, when a supplier is chosen by the client, when Boeing chooses its suppliers, when General Motors or Harley Davidson chooses one of its 1,000 tier 1 suppliers, they make them sign their contract. And that contract, as you said, can last for many, many years. and it is rarely modified.
Yeah.
And it is dictated usually by the strong party, which is Boeing or GM, but not always. If there is a very strong supplier, let's say, Michelin tires, they can also dictate to their buyers. But in any event, the master agreement governs the general relationship. It doesn't determine how much is sent and at necessarily what price for each shipment. Now, Boeing needs more, there is a slowdown or there is a pickup in pace of production, and they need more or less, passenger seats to order. So these type of supply agreements of the actual quantity that we need to be shipped, delivered when and to what facilities and at what exact price given change in prices of the other things in the market, they will determine usually through website. They would usually do it, and so all the suppliers would have to have accounts on the Boeing interface, and that's how they will do it. They would do these things digitally. In the past, the purchasing agent would pick up the phone and dial the number and call and say, hey, we need 5,000 units of this particular gadget, and that would be they will send forms. Now it's done digitally.
Got it. Okay, thank you.
There are some chat questions. Katie, do you want to choose and read?
Sure. So it looks like we have a question from Renee asking, if a consumer doesn't agree to the contract or the terms, can the business legally block them from using the site or the app?
This is the world of take it or leave it. If you don't like McDonald's price for a Big Mac, and you say, well, I'm not going to pay $3.99, I'm only going to pay $2.99. Can McDonald's deny you the Big Mac? Now you know that the answer is yes. Just take it or leave it. Nothing is different between that and how it's done digitally. In fact, it's even more clear because unless you click, I agree, the website or the app will not take you to the next page. And so I think everybody realizes online how much it is a take it or leave it world. Now, don't be naive, though, to think that that means that the business has all the power. Consumer, they have the power to determine the terms, but the consumer may go to another business. And in many platforms, consumers have a lot of power because they have a lot of choices. When you want to buy something on Amazon, there are a lot of sellers. Each seller sells it in their take it or leave it terms, their price, their shipping charge, but you don't have to take it because others offer potentially better terms. So yes, Renee, the answer is if they insist that you accept their terms and they don't give you an option, you cannot decline the terms and continue. You decline, then you're out.
Great. It looks like our final two questions are related to canceling contracts. So a question is, what is the best way to cancel a digital contract beyond the cooling off period?
So, right, good. Cooling off periods are given let me just clarify, are periods in which consumers have the right to retract, to cancel it without having, without any limits. So when you buy travel on United Airlines, they give you a 24-hour cooling off period. You can cancel and get all the money back. After 24 hours, you cannot cancel automatically, depending on the terms of your fare. You may buy a fully refundable fare, which means you can cancel, or you may buy a non-refundable fare, in which case you cannot cancel, and changes might be subject to some limits or fees, although recently less so. Once you have created a contract that and the cooling off period expired, and you're bound, and you cannot walk away, you cannot withdraw, that's the legal term, then you are, depending on the terms of the contract, If you signed up with a gym for 1 year for a lower price, you're bound for 1 year, no cancellation. But if you signed up for pay as you go every month, you can cancel probably by the end of the month or sometimes even midway through the month. But you have to find out how to cancel. And that's where we run into some dark patterns. Believe it or not, I mean, it seems obvious, but unfortunately obvious, businesses and websites could make it very easy to start a plan and not as easy to stop a plan. Very easy to accept a transaction, not as easy to cancel. It shouldn't be that way, but we understand why it is that way. The most important thing is for the businesses is not to make it too difficult, not to do what LA Fitness does or what to do. You know, there have been all sorts of horror stories in the history of digital contracting, what Yahoo used to do in the days when there was a Yahoo, how hard it was to stop the monthly payment from going on. There is an aspect, though, of termination that people are not aware of that is becoming also part of the more prominent, and that is what happens with your data, everything they know about you after you terminated the contract. So you no longer are signed up for a, I don't know, a Fubo TV or Hulu. You don't no longer pay $50 a month to watch content. But you did so for several years. They know a lot about what you like, what you watched, where, how long, what you stopped in the middle, what you liked especially and watched over again, what your tastes are. Some things are very private of the thing, and everything is stored and profiled about you, not by people, by algorithms. Now, many people don't think it's great, but they, you know, doesn't bother them but to some people, this might be a critical aspect. Once I leave the platform, I want you to forget me. So increasingly, there is around the world a right to be forgotten, to require that once termination occurs, you also terminate your memory of me. Not in the US, only in Europe. I'll just mention that even though this was enacted in Europe by the European Commission and the European courts to great fanfare, very, very, very few people have ever asked to be forgotten. And it's mostly celebrities. So it's not so much a right of privacy as much as it's a right of publicity, but it is another aspect of the termination that is hard to get going. Yeah. Another question?
It looks like these two questions are related a bit to what you just discussed, but is there a legal amount of time that a business must allow someone to cancel their agreement?
No. A contract doesn't, can be binding instantaneously. I'll give you an example. You want to buy a home, $300,000, a condo. You sign, you sign. A split second before signing, you are free to walk away. A split second after signing, you have to cough up $300,000. No way, there is no kind of, oh, maybe I'll need some time to think about it. Think about it before, not after. Now, sometimes businesses or contracting parties, out of their good nature, to put it, if you want to put it this way, are willing to give a time for people to withdraw. Maybe they think that this makes it easier for people to click, I agree, because they know that they can withdraw. So they lure them in this way. But they don't have to do that. And therefore, there is no obligation. And it's a very important element of the consumer interaction with consumers, users, and others, is to think what kind of a cooling off withdrawal plan do you want to give, if at all?
Great. It looks like we have one other point of clarification in the chat, and then Pranay, I think you will be our final question for the day. So Himanshu wants to know, for how long can a business keep or store consumers' data after the digital contract is canceled? It sounds like in America, they can keep it forever. Is that accurate?
Okay, so most of the data that businesses are collecting, other than data about the actual transaction that they were part of, when you bought something from a store, they can keep the record because they're side of the transaction. But when Target.com plants a cookie or something in your computer that broadcasts a lot of your personal information, or when Angry Birds app tells the big mother bird everything about who your friends are and who you call and where you drive and what you do and all the other apps, very curious birds. These are information they don't need for functionality, and they're not allowed to take unless you agree. So the terms of service give them the right to take it. Everything, all of the data collection enterprise that runs our economy is based on users' consent, because most of it cannot be collected without consent. These consents, these terms of service, privacy policy, cookie policy, I showed you some examples how they are being consented to. These can state whatever they want. There are some limits. You can't take information from kids, even if the kids or their parents agreed. You can take some medical information unless it is necessary for treatment. But other than limits that are created by law, and there are very few, everything is fair game, including how long they will keep it and will they ever give it back or surrender it. Facebook has so much information about people, so does Google and many other websites and platforms. And they made sure in the terms of service to grant themselves the right to do whatever they want for as long as they want with this data.
Great, thank you for clarifying. Pranay, would you like to ask our final question for the day?
Yes, no, thank you so much for the opportunity for my follow-up question. And it's been a great session. I've learned a lot. I just wanted to ask, so after the GDPR was enacted in the European Union, in your experience, has that contributed to a slightly more level playing field between mass consumers and large corporates? Have you seen any positives for us to sort of end on a more positive note? It's a slightly daunting session today. I hope we all start reading our terms and conditions now, but just anything positive happening which is sort of drifting the power away from large corporates to mass consumers.
So yeah, I think Pranay's question that refers to a regulation that came out in Europe 3 years ago and 2 years ago in California, and more states and countries are following up, that trying to limit the ability of websites and platforms and apps to collect personal information, create some limits, and create more prominent consents. So if you noticed about 2 years ago, you started seeing more of these pop-ups every time you enter a website that block the content and tell you about the cookie policy or the data tracking policy. And that is courtesy of the European regulation. And this is done by any website that has any interface with European consumers. Whether that changed much, so far, I don't think so. I think that the most of the changes that it led to is for the websites, the businesses, to have clearer explanation of their privacy policies. So Google revamped their privacy page, and they call it now privacy by design, and you can choose what to block and what not to share and what not to track. And those things are easier if you care to do it. I think that it would be a gross exaggeration to say that 1% of the population took advantage of it. I think the numbers are much, much lower. People just don't have the patience to manage how much they're being tracked and exposed. They don't care that much, and as long as they don't, not much will happen as a result of these regulations.
Great. Thank you, everyone, for these great questions. And thank you to Professor Ben-Shahar for being with us today and sharing your expertise with us. We will let you get back to your football match shoot. But is there any last bits of advice you'd like to leave our audience with today before we sign off?
If you got the impression that it makes sense to read things before you agree, I think this is going to be a very costly impression. Because if you even tried to read some of these things, it will be a very bad way to spend your time, and you most likely will not understand. And anyway, you don't have a choice, and you want that Big Mac. So no, the question is not so much whether to read, but if you are interested in doing business, try to make it in a simple and not to trick or to manipulate the other side. That will ultimately not play to your benefit.
Great. Thank you so much again. Thanks to you all for joining us, and we will see you at our next workshop. Have a good day, everyone.